next speaker is Werner, and announce the next speaker, who is Werner Eyskens. Werner Eyskens, I have suggested his name to Lara for inviting him to this wonderful conference because he has a broad experience in accompanying and supervising bankruptcies. He's based in Brussels, and then you know already where my line of thoughts are going to, and he started there in the late 1990s in the law firm, which most, if not all of you will know, Allen and Overy, and he's a partner there, and he supervised, among other things, the Swiss Air Sabina, the Sabina transactions in relation to Swiss Air after the demise of Sabina in 2001, one of the oldest airlines of Europe. 1923, I believe it was born, so to say, and I believe that is a great experience from which he will go into some of the aspects which have already been touched upon by Mark in the previous speech, but he will approach them from a somewhat different angle. Werner, the floor is yours for being here.
Thank you, Pablo, for these kind words of introduction. It's a privilege to be here, invited by the Business School and by Laura, so thank you for that. It's a pleasure to be in Rome. My Italian is less fluent than Pablo's. I have to admit that my big example when I need to talk Italian for me is Nigel Mansell. Some of you may recall him. He was a Formula One driver. He must be retired now in the 80s. And I recall that whenever he finished a race, Italy being a car-crazy country, he was besieged by Italian journalists and media who would ask him tons of questions in Italian, and Nigel always got away with one single answer, and that was "La macchina va bene." And I use that answer to any question which is asked to me in Italian, and I find that it satisfies most questions. I'm going to talk to you about insolvency, bankruptcy. Airline insolvencies are dreaded because they are highly visible. And somehow they weigh more on public morale than many other bankruptcies. And the picture I'm going to show to you, indeed, as Pablo announced, comes from Belgium. The eventual homecoming of the last aircraft of a carrier which just went bankrupt inevitably causes these kind of very emotionally charged images that capture a lot of media attention. And this was the last aircraft of Sabina coming home on the 7th of November 2001. Now, because airlines are geographically or have geographically very widely spread operations, the discontinuity of their services raises a lot of operational problems. Those problems remain very difficult, and that is to a certain extent surprising because there's a lot of experience with airline insolvency and bankruptcy. I wasn't aware of public figures of EU bankruptcies, but Pablo, clearly better informed than I am, just that there had been about 1,000 bankruptcies in Europe. I know that a study by Professor Dempsey of a few years ago calculated that in the US since 1978, 170 US carriers had gone bankrupt, so you would think there's a lot of experience, but the problems remain. In Europe, indeed, I think one of the, among the highest profile bankruptcies, true bankruptcies we have seen involve Sabina and its at that time related carrier Swissair, and I will from time to time come back to that experience. I would like to perhaps tell you a few words about the causes of bankruptcy. A lot of the causes are generic, as for any enterprise, but I think there are a few specific causes for bankruptcies in the aviation sector. The first cause is increased competition. That is something, a result which was really sought after, especially after the liberalizations in the 70s and the 90s. That is clearly a cause. Another cause is, I think, a rare combination in the aviation industry between high funding costs, specifically for the aircrafts, and very elevated labor costs too. The airline industry is an industry which needs to cope with operations with very high fixed costs. And the reason why I'm saying this is that Not carrying out for an airline a scheduled flight is not going to save it a lot of cost. It's not going to make a big difference for the P&L of an airline not carrying out a flight. So they have very high fixed costs. It's also an industry which is affected by excess supply, and that's not going to change because it is something which is also specifically sought after. I think there is a demand for excess capacity to absorb peak demand. So there is an excess supply which is structurally within the industry. There are only limited ways to differentiate products for the different carriers when they compete with each other. Carriers have been inventive, but it remains limited, a possibility, of course. And I think a final and very important feature is that the products which carriers sell, i.e. seats, have a very limited shelf life. They need to sell the seat before the plane takes off. And I think that explains why certain airlines have, on an individual basis, the very rational reaction to lower the price, even below their own cost structure, in an attempt to sell seats before the plane takes off, because any price is better than no price. And what is rational on an individual basis becomes pretty irrational when all the airlines start displaying the same behavior. Because if, as an industry, all the airlines start to do that, the market starts to expect that seats are sold at prices which are structurally loss-making for the industry. Another short comment I want to make is that, I mean, obviously in a bankruptcy scenario, the ownership of assets is key. As Mark already explained, most airlines most aircraft and most airlines now have only leased aircraft, so there's another owner than the airline, and that raises a lot of problems also because the leasing arrangements around these aircraft are very often tax-driven, which makes them very complicated. Very often the only way of trying to explain what the structure behind such a lease structure is a large chart, which resembles more a fragmented bomb explosion than anything else. And that does not help when an airline becomes insolvent. And a very final comment I want to make is about a disconnect which exists sometimes between the economic value of the operation of a route from the perspective of an airline. For an airline, it should be pretty straightforward. A route should be profitable or should feed passengers or traffic to another route which is profitable, so it's pretty straightforward. But for the airport, which is connected by a certain route, the area around the airport enjoys the beneficial fallout of being connected to a route. And that raises other economic interests, which can become pretty political. And they can be, and that is specifically the case for carriers which are connected to states and public authorities. There can be a pressure on airlines to continue to operate certain routes which are not necessarily in the airline's economic interest itself. Now, I won't go into the signs of bankruptcy and insolvency. I think the time to do there is not there. I will talk a bit about the effects of bankruptcy. First, perhaps an introductory comment on this from a lessor perspective, and Mark, I think, touched upon that too. From a lessor perspective, the EU is not at all a uniform legal market or environment. And I'll give you two very brief examples to show you how different Europe can be. This is a map of some selected jurisdictions in Europe, and what I try to show here is the difference in regimes which exist for a lessor who tries to enforce a clause in a leasing contract which allows him to automatically terminate a lease contract upon insolvency. And as you see, the red-colored countries are generally lessor unfriendly. We've simplified things here. Termination will not be straightforward. The green jurisdictions are pretty lessor friendly, and the yellow jurisdictions are probably require a lawyer's answer. It depends. Sorry, the light green in this color. Sorry, I didn't see that. So the really green ones are the Netherlands and Belgium here, and the light green was the UK and Germany. Sorry, the colors come out a bit different on this slide. Another example here is about priority ranking for claims which lessors may have for lease rentals which remain to be paid, whether or not they have any priority. Again, there's a big difference. Certain countries are not very lessor favorable, generally speaking. Other jurisdictions, for example, Spain for leasing arrangements is much more lessor friendly. And then Germany, France, Belgium, and Netherlands has a kind of a mitigated approach. So there's a big difference, as you can see from these just two examples, between different jurisdictions. Suppliers obviously come into play in bankruptcy, and the typical problems which suppliers will face a bankrupt estate with is liens. Most lease documentation will exclude the possibility of liens. That is a typical clause you will find in there, but it tends to be wishful thinking. When an airline goes bankrupt, everybody starts inventing liens, and many jurisdictions are very sympathetic to that. One typical example will be maintenance providers, and they will have a good claim in many jurisdictions on the aircraft which they may have under their control, and which they may be entitled to withhold until the invoices are paid which the bankrupt carrier owes them. And that can even apply to other aircraft of that same bankrupt operator. As I said, many lease documentations will exclude the possibility of liens. That's helpful, but I think it's much more helpful for a lessor to insist to see the written waiver by service providers that they will not rely on liens. You will also have what I call de facto liens. De facto liens is something I think, in my experience, lessors are faced with when they're trying to repossess an aircraft. On certain airports, there's only a limited number of service providers. I'm thinking about ground handlers, navigation services, and the lessors who want to repossess need to secure the cooperation of these providers to get their aircraft out. And very often, it's just a factual situation. They will say, we don't help you unless you settle the invoices of the bankrupt carrier. And very often that happens. Finally, and the time is not there to go into detail of this, but many of you will be aware of the dreaded Eurocontrol fleet liens. I know that the CAA plays a big role in that, so perhaps one of my panelist colleagues will say a few words about that. The consequences for the carrier. After the bankruptcy, there'll be a trustee who takes over the management of the company. The big difference obviously being that the trustee does not report to the board or to the shareholders, but to the court. So that's a big difference. Typically, a trustee is expected to liquidate the company, but something which we've seen in a number of bankruptcies is that the trustees seem to opt more for a long-term unwinding project in an attempt to maximize the value of the assets of the carrier, the bankrupt carrier. That will lead to conflicts. Many creditors will prefer an immediate liquidation dividend and carry on with life, rather than becoming embroiled in a long-winded crisis management program with uncertain outcome. Traffic rights can get lost, and the AOC of the carrier will probably be suspended, even though the carrier as a legal entity continues to exist. Many of you will be aware of the wonderful IATA clearinghouse services for inter-airline account settlements. That is obviously a breeding ground for post-insolvency litigation. Something I've seen happen too is IATA's influence in allowing a carrier to keep for a certain time the call sign, because the call sign, as has been discovered, has quite some economic value, and a trustee may try to monetize that, specifically in a start-through project. And I'll just say a few words about, and there I think Sabina and Swissair examples come in, the start-through projects. I mean, specifically when flag carriers become insolvent, there's quite some state intervention. I think it is a political reaction in an attempt to secure employment, in an attempt to maintain a route network which is there. And the idea is to allow a start-through project, i.e. another airline to rise from the ashes of the bankrupt one. Normally, project names are assigned to these projects, and invariably it's called something like Project Phoenix. That is always the code name for these projects. Now, state aid is obviously a big issue there. What I've seen very often happen, and that is also very political, is that what is called patriotic private investors are nudged which have nothing to do with the airline industry, are nudged into investing in these projects to get the new airline going. Today, Brussels Airlines and Swiss Airlines are the results of these kind of projects. So they work. I wanted to say a few words about the liability consequences, but I'll be short on that. Perhaps I'll limit myself to one comment about a typical shareholder liability. I think when there are more than one shareholders, very often you'll have shareholders agreement, and very often these shareholders agreements contain wording about support which shareholders are expected to provide to the airline. And these support undertakings are always drafted in a bit of a vague way. They will contain wording like efforts, and I'll give you one example, which was in the Sabina shareholder agreement, this one. And it said, SR Group, which was a Swiss Air holding company, expresses its resolve to keep Sabina in a position allowing it to meet its obligations in line with its, i.e. Swiss Air's, firm policy towards the members of its group. This line has kept, I think, a small busload of lawyers and courts busy for about a decade to try to understand what exactly this means. I'm going to skip over a few of the further comments in order to respect the slot which I was assigned. I will just say a few words about repossession as a final comment. I won't go obviously into the Cape Town Convention. I would like to say a few words about the Rome Convention. I thought this was a very proper venue to address the Rome Convention. As many of you will know, in most jurisdictions, self-help is not allowed. You cannot just, as a lessor or owner, if you want to take back your aircraft, go and grab it. You need a court order, a freezing order. Now, there is a 1936 Rome Convention on the precautionary arrest of aircraft, with not that many member states, but quite a few in Europe. And it's, the principle of that convention is that you cannot arrest aircraft. It is prohibited to arrest, to attach aircraft. So that is a bit of a problem. There's one exception to that rule, and it is that owners who are dispossessed of their aircraft by an unlawful act, well, they can actually attach their aircraft. There's been quite a debate to try to understand what this sentence means, but in the last few years, we've been able to convince courts that a situation in which a lessee refuses to hand back an aircraft to a lessor after the lease term was terminated, that qualifies as an unlawful act. So it is possible to get freezing orders. I will try to, perhaps, to respect the timing, bring you to a few conclusions. I think I can make one conclusion I can make is certainly for airline bankruptcies. They tend to be lengthy and messy processes, and I think that is explained by the very operational nature of their activities on the one hand, and also the financially and legally complex structure behind their funding systems, specifically for their aircraft. I think that explains the complexity of many airline bankruptcies. I think because it also affects employment, and because it's very visible and quite emotional, in my experience, before and during the insolvency process, there's quite some political interference, specifically for flag carriers or carriers in which the state maintains a stake. In my experience, for the lessors who play an important role, what they do is try to get their asset out as quickly as they can. That's the most important thing for lessors. They worry about the recovery of their claims at a later stage, to the extent that is possible, because they're very often faced with an insolvent debtor, of course. The one final comment I can tell you is that the repossession of aircraft is, for many lawyers, and for myself in any way, one of the occasions to get away from my desk and to see some real action, to get on the tarmac. So I want to finish with this image, which is one aircraft we got and were able to repossess. Thank you.
Werner, you deserve applause for your very analytical and multifaceted approach towards this complex situation which arises after bankruptcy, but not only after, you also identified the causes of it. And I must say that I was very much impressed by, well, I could sense, let's put it that way, the lots of thought and wealth of experience behind each line of your presentation. Didn't have time to express all of that, but I know that should there be questions for you, that you will be happy to answer them if time so permits, because I know that you have to leave in not too long from now. Thanks a lot for that valuable contribution to our discussions of this panel.